Love you, Linda. Love you.
The courthouse the other day in the hallway, you're singing "Oh Happy Day."
One word prayer. Justice, where are you?
And Justice Served TV is on the air. Hi, Linda Kenney Baden.
Michael Bryant, I'm
Hey.
conversing with our other friend who actually left us high and dry the other night. Actually, he didn't. It was Jimmy
You talking about
Angie.
Jimmy?
He was exhausted, just absolutely exhausted. But he promises to come on. I'm going to keep it a secret because maybe you'll be around when he comes on next. But he just said yes to that other conversation that I'm sending you. But for our viewers, you'll have something to look forward to in the future. Auntie Deb will be on in the future, not too far future either.
Well, I hope he recovers from his extravaganza from last Friday night. So, we're going to do something. Yeah, I'm sorry.
No, that's fine. No. I'm just accepting. I'm accepting his proposal. That's all.
Oh, all right. Well, congratulations. I realized we don't have any rip and reads tonight, but that's okay.
Because you know why?
Why?
We've been so busy today.
We've been ripping other things. We have, this Massachusetts versus Kelsey Fitzsimmons case is unbelievable. And, we had been kind of dipping our toe into it. And I mentioned that earlier on a little notice about what we were up to. But the more we got into it, the deeper disturbed I became, more deeply disturbed at what this judge has done to this defendant, former cop, mom. It's just, and we should get the judge's name out there. I've seen it with and without the hyphenated version, but Kathleen McCarthy Naiman, that's the hyphenated part, Naiman, in a town there in North Andover, which is just north of Boston. It's about equidistant north as Dedham is south, so roughly 45 minutes north of Dedham. So their own little universe there, and it's bizarro world. If you never thought anybody would find a more challenging, and I'll use that kind word, judge as Judge Beverly Cannoni, wrong.
Hold my beer, as they say out there in the world.
Wrong. Kathy McCarthy, Kathleen, is a doozy, and not in a good way. So what we thought we would do is kind of go back and talk about what this case is, what this defendant is, and what's happening in this case. Her attorney, Tim Bradel, you may be familiar with, and I've sent a note out to him, as I have for some time now, and I'll be honest about it. When I met him on the steps of the courthouse last time I was up there, and I'll see him again next week, I said, look, I've been doing this for decades. You will not be the first person to say, yeah, I'd rather not do an interview. I'm fine with that. And he's like, no. I need to make sure that what we talk about is, I've got ongoing cases. And of course, he represents Aiden Carney. That case is ongoing. I said, fine, then I will continue to bother you, which I have done. And we haven't worked it out just yet. But now we have a second reason to, and that is this case, which is so different in nature, but so outrageous in similarity, if I can put it that way. How do you want to start? You want to jump in with some of the basics? You want to look at some of the documents we have?
Let's do some of the basics, and let me tell you why I became interested in it after we looked at it. And the other night I think I called her Kelsey, Fitzsimmons. This shines a light on a very important issue, this case, and we're going to be talking a lot about in the future. And it's going to shine a light on postpartum depression. All right. Let me just give you a little bit of a history about postpartum depression. It used to be that people took it off as like the baby blues, and it wasn't anything. And in England, when postpartum depression, there were cases, and we had one here in the United States, Andrea Yates, where women have been accused of murder. In England, within a certain period of time, I think it's 6 months of giving them a baby, you can't actually be accused of infanticide because they recognize postpartum depression much earlier than we did as the United States as a real thing. It's a real psychiatric condition. You need mental health and you need support. And there are so many women so many women that have had it. And you and I have just taped something that we'll be releasing. It's a very short episode dealing with Brooke Shields and some other people, a little short, to get a primer on postpartum depression. And we're going to be looking at a longer show. But it is something that affects women very seriously. And it has to be treated, and we'll talk about her treatment here, but it has to be recognized by the legal system, not some, excuse me if I say this, asshole, judge. All right, I didn't say that because I'm a lawyer and I'm not allowed to badmouth judges, but you have to take that into account in this case. And so everything, if you're female, okay, when we're talking about the background of this case, if you have anyone who's experienced postpartum depression, knows about postpartum depression, think about that in context of this case, because in context of this case is huge. And with that little bit of a mini rant, Michael, I think we can talk about the back.
Yeah, and to be honest with you, I think in this particular case, we're going to learn how postpartum depression led to an altercation she had, led to this person being shot, but being the one arrested, shot by a fellow cop, a friend, which led to physical issues, which then led to problems complying with the court's order regarding her release from jail. I think the postpartum depression is an overlay that makes it even worse. But if you just cut that out for a second and have a defendant in front of you that has some physical limitation, right, and can't perform the required test that is part of their release agreement, right? Why can't you make modifications for that person? That's the crux of the current issue, regardless of how the postpartum depression is truly an overarching problem. We get that.
Right.
But let's get into it. Let's do it this way, because there is so much that's out there.
So much out there. And I have a feeling this is going to be part one of a two-part show. That's my feeling.
That's very possible.
Yeah.
We
and 3 parts when we talk about postpartum depression or postpartum psychosis, which are 2 separate things.
Okay, so let me find part one of our dissertation here. This is from Tim Bradle, a letter that he did in July. Let me back that off here so we can see the whole thing. It's in July for immediate release. Well, we're not immediately releasing it because it's not July, but this just gives us a good foundation for this case. Okay. As he said then it's time to end the PR war on North Andover police officer Kelsey Fitzsimmons, the defendant in this case. As Kelsey recovers from her life-threatening injuries, she cannot sit idle any longer. So here's what she had to say. My name is Kelsey Fitzsimmons, and as I recover in my hospital bed, I'm ready to speak about the incident that took place on June 30th, 2025. This is not ancient history. We look at so many cases where you're going back 10 years, right?
11 years, right?
This is a couple of months. In my own home where I almost lost my life. I was diagnosed with postpartum depression in March of 2025, approximately 3 weeks after giving birth to my beautiful baby boy. That was the end of February. I have actively been in treatment since the day of my diagnosis and was eager to heal and feel like myself again. Unfortunately, healing a sickness does not happen overnight. However, what can happen overnight is my life turning upside down into something so horrible, my mind wouldn't even be able to imagine it if it weren't my current reality. Someone who I thought understood my diagnosis, loved me in sickness and in health, and was in my corner for the journey of my active treatment to get better, turned their back on me. Said person is now legally bullying me to get what he wants, slandering my character and using my diagnosis against me to make me seem like I am a monster. There are more false allegations that I could even comment on. Okay, this is the father of the baby by the name of Justin, and I there are many apparent pronunciations of his last name, but Alien, something to that nature. Anyway, a deep love I have for my baby boy sustains me and keeps me strong. I haven't spent more than a night away from him since I delivered him, and I adore every moment I spend with him. He's my best friend, my miracle, my little man, my sweet boy, and most importantly, a giant piece of my heart. Right now, that piece of my heart is missing when I need it the most. I am 5 months postpartum without my baby boy who needs me as much as I need him. I would never put that angel of a child in harm's way. My job as his mama is to protect him, and that is what I have always done and will continue to do for the rest of my life. Becoming a mother has always been my dream, and I never made any threats towards my baby. That allegation specifically makes me sick to my stomach. I was alone with my baby day in and day out for months, caring for him as my fiance frequently worked 24 to 48-hour shifts. But conveniently, there were never any concerns up until now. Fireman, right? He's a fireman?
Right.
Okay. On June 30th, 2025, I received a phone call from my fiance to meet him at the park to go for a walk with our baby boy together.
Due to get married October, allegedly.
Yeah, early October. I think October 4th was the date at the time. After almost 3 hours of waiting for him at the park and no communication from him, I went home very confused as he never showed up. About an hour later, I was sitting on my couch feeding my baby boy when I got a knock on my front door. Very confused to see three of my colleagues. Again, she was a cop, right? Three of my colleagues. I open the door and I'm told the following. Your fiance has filed a restraining order against you. He will be taking your son away with no contact allowed. Your firearms license that was just returned is gone again. And oh yeah, that career you worked so hard for and love that you were just cleared to return to, that will be taken away too. Following this interaction, I packed bags containing baby food, clothes, diapers, toys, etc. for my son to be taken away from me. I passed my son off to a fellow police officer and I went into my bedroom. In that horrible moment, I didn't want to live after my whole world was turned upside down in a matter of 10-second conversation due to some allegedly horrible, untrue things. We have a broken legal system where someone can walk into a courthouse, write anything that self-serves them on an affidavit, and as a result, a brand new mother suffering with postpartum depression gets her baby taken away. We are calling on the legislature and the governor to reform this abomination of a statute where the first person to get to court and fill out a form can take a mother's newborn away from her if they can sneak in front of a judge without the mother's notice or opportunity to be heard. If there is an immediate issue, someone can call 911. The courts are not equipped for proper on-the-spot decision-making in this context without hearing from both sides. As a police officer, I am trained to know what to do if I encounter a suicidal individual who is only displaying a threat to themselves. I certainly was not trained to shoot a suicidal person in the chest, but here I am today, 2 surgeries later, bedridden, and really trying hard to heal from these significant injuries. I'm facing felony charges for a half-hearted attempt to take my own life. Let me say that again. I'm in trouble and have a gunshot wound to my chest because in that awful, isolated moment, I no longer had the will to live. I never pointed my firearm at the officer. The officer was not just a colleague, he was a friend. That officer and I experienced a very difficult and sad call for service together last summer. That call for service that day was a true tragedy and caused this officer and I to build a friendship due to experiencing it together. We entered the home and walked into something no human being should ever see, a murder-suicide scene with a mother and her infant. As a rookie police officer, this was devastating to me. At the time, I was 20 weeks pregnant. The officer that shot me experienced this call with me. To this day, his support during that hard time is something I am still grateful for, regardless of this recent incident that occurred. This traumatic murder-suicide call was the catalyst for my mental health complications. As a police officer myself, I would never even think to intentionally hurt another police officer. I see everyone in uniform as my brothers and sisters. I especially would never hurt my friend who has a loving wife and children. I just would never. My firearm was never pointed in any direction other than my temple. When I pulled the trigger, my gun did not fire. However, I immediately got shot in the chest by my colleague and friend. I am extremely grateful for 2 things: that God protected me from my attempt of taking my own life and protected me by millimeters from dying from that gunshot wound to my chest. I will survive and thrive. I know I need to be on this earth for many reasons, but most importantly, my beautiful son. This is my covenant with God and my son. I would also like to note that from the very beginning, I acknowledged my diagnosis of postpartum depression and immediately sought help from medical professionals. I was failed in so many ways by so many. Narrative that has been released by NAPD is vague and non-committal for a reason. If body cameras were worn by my department, I would not be in a position where I am wrongly accused pointing my gun at this officer. I know the truth will prevail. So that is a heartfelt story from the defendant now, at that time, the victim of a gunshot wound, and she has survived that. She was in the hospital 50 days, 52 days, I think, something like that.
Right. And you were, as you were reading that, I know you were all asking yourself, what's the body worn cameras? Where's the axons, right? That we have.
Exactly.
You have the answer. The department doesn't have them. So how did we get to that point? So I feel like we're in a movie set because again, this is just a terrible situation. And she was a North Andover police officer, as you know, Kelsey Fitzsimmons, 28 years old, right? She had been on administrative leave from the department at the time of the shooting and her license had been reinstated. It was taken away from her. Why? Because when she was in the hospital, because of the postpartum depression, she was put into a mental health hospitalization at Lawrence General Hospital. And those up there would be familiar with that. Okay. So a restraining order gets signed, a court order gets signed, and an abuse prevention order, as they call it up in Massachusetts, to be served on her. And since she is licensed to carry firearms, the affidavit that came with it from her then lover, boyfriend, father of the child, right? Still father of the child, I gather. But we'll talk about what happened yesterday. Okay, so that she could become reactive if she were served. Why? Because she has postpartum depression, because she has a psychiatric condition, right? The order was issued by the North Andover Police Department, which is where she is from, at 4:31 p.m. At 6 p.m., the three officers went to her house. That's what you're seeing right there. Okay, she was administered medical care. But what had happened that brought this on? Well, the man, the father of the child, the then fiance, they both had a lovely young child in February, and he filed the restraining order along for what is called a complaint for protection in Massachusetts. Every state is different, but that's what it's done. Claim for protection from abuse, right? With the family court, and I think it's called the Essex County, Essex Probate and Family Court in Massachusetts. He said that on the previous Saturday night, this is Monday now, the previous Saturday night, Kelsey Fitzsimmons had abused him by striking him three times in the face with a closed fist, left him in fear of his life because of that, and that in fear of physical harm would come to their baby, all right, that they had together. And he said that there had been a pattern of what he called concerning behavior or concerning abuse on behalf of by Kelsey Fitzsimmons, that she was clearly a danger to him and the 4-month-old. Why? Because during her pregnancy and after birth, she was physically abusive to him and to herself. Okay, that's what's in the act, to him and to herself. These are, by the way, classic signs of the postpartum diagnosis. Okay, and that he apparently moved into a hotel, but other people said that she was still crazy and combative, and that's why he thought that he should file for a restraining order, and that she had said to him these words, and these were the words that I think led the court to doing what they're doing. The affidavit from Justin said that Fitzsimmons had said on Monday she planned to take the baby, quote, far, far away for a long time. Let me repeat that. That's Fitzsimmons had said on Monday that she planned to take the baby far, far away for a long time. And he claimed this is what Kelsey Fitzsimmons said when she talked about taking her own life, being suicidal in the past about herself. And then the affidavit also told the judge that she had been involuntarily committed by what's called Section 12 in Massachusetts at Lawrence General Hospital for a health stay. And of course, the health stay had to do with the postpartum diagnosis that she then got, right, and was under treatment for. So that's how we got to Monday night. He claimed fear for himself and fear for the child on the basis of the words that she planned to take the baby far away, which he interpreted and told the court was that she was saying that she was going to kill herself and the baby, or at least the baby. So
again, this is based on his word alone. There's no corroboration, right. Just his story. Okay, so now we have what happened that night. So what do we have most, immediately after that with the charges? She's first of all, she's in the hospital. She's in the hospital for 2 months almost. But then there's an arraignment ultimately. So let's take a look at some of the arraignment. This is Tim Bradle. He does all the talking, but you'll get to see the defendant. You'll get to see Kelsey Fitzsimmons just to get a sense of what she is in terms of stature, and he gives us a little bit of a recitation as well as to what is going on.
And that's actually her standing there.
Something about the wrecking ball to the case. The grand jury only came back with a very less significant charge.
Yes, they initially, the theory of the government's case here was that Kelsey intended to murder a cop, which is outrageous and completely ridiculous of an assertion. And here, thankfully, the Essex County grand jury, and Kelsey's extremely grateful to that body for looking at the case in a realistic way. They found that their appropriate charge here was 1 count of assault with a dangerous weapon, which involves the apparent display of a weapon to cause someone to be placed in fear. A very, very low bar, and that's all they came back with, was that one charge. And if you look at the sentencing guidelines, she's in a position where she could very likely get a probationary sentence on this if she were guilty of it, which she is not. But the playing field has been radically shaved down. It's just really a totally different case now.
It seems like we're seeing a lot of these cases in recent times with the postpartum. Is she just having some issues that you made the argument today, so she can continue on trying to get some resolve to that?
Yeah, I mean, postpartum depression, one of the most common afflictions that a woman could have, giving birth, having a baby. It's a transient condition. That's the biggest word of the day on that, is that our experts and the Mass General experts recognize that postpartum depression is a transient condition. That's gone. She's fine. She needs her baby back. She's never been heard in a court. The only body that's heard any evidence is the grand jury. And even there was no cross-examination. And they still put the brakes on this. They still said this is at best, as a matter of probable cause, the lowest standard in the law, the lowest hanging fruit, that at best this is an assault. And it's just a completely different case. And like I said, the grand jury took a wrecking ball and destroyed the Commonwealth's case and completely rejected their theory that this was any sort of an attempted murder type scenario. This is a woman who was suffering from an affliction, who, based on words on a piece of paper, had 3 policemen come to her house and take her 5-month-old baby. A woman who's in the grips of postpartum depression, who was just scheduled to go back to work at the police department, was cleared, had her firearms given back, and her whole world was taken away from her because a guy went to the probate court right over there, filled out a piece of paper full of self-serving allegations, and got her baby. So that's what we're dealing with here.
And
unimaginable.
What do you make of the judge's order today? Obviously, she's going to be able to go home, get out of prison, get out of jail. Is that sort of a step in the right direction?
Yes, the case is going in the right direction, and we appreciate Judge McCarthy's attention to the case.
Remember this. Just remember this initial reaction to Judge McCarthy as this unfolds. It's unbelievable.
I think that she is being extremely cautious with the amount of conditions that she put on the case, but we will endeavor to comply with every condition she wishes, and we're committed. Kelsey is very committed to showing this court, showing the judge that she's fine, that she's in control, that she's not a danger. The only thing that's been aggravating her postpartum is having her baby taken away, being on the receiving end of these self-serving allegations, and then being charged with a heinous crime that ultimately was rejected by the grand jury. So we're now going in the right direction here. We're very optimistic that this case is going to get dealt with in the appropriate way. And for the short term, we respect the judge's ruling. We're happy to get these conditions in place, and we're going to show the court that this is not a problem for Kelsey Fitzsimmons. She's a cop. She's a CO, former CO. She's not some criminal who needs to be clamped down. And she's going to show that to the court, that she's going to handle these conditions and she's going to do just fine.
When will Kelsey be released to her family?
Well, I think that through some Herculean efforts to get the court to get all these things in place, I think it's going to be tomorrow. So we're going to be very happy about that date.
Well, parents put a lot on the line. The judge had them swearing. Do they want to say anything about their daughter?
Mom and dad and stepdad are wonderful, and they have put so much into this, and the families put so much effort into this. And I was just saying to them inside that when you have a great family behind you in court, literally they're behind you in court, that makes my job so much easier to say, Your Honor, look at this great family that's going to step up and make this right. And I think Judge McCarthy would agree that, it makes a huge difference that she can see this family, and they stepped up in every way she asked, and they're going to make sure this is a success. We're not in any way concerned about that.
And there is a hearing coming up on the restraining order. What are you hoping happens there?
So we're going to assess our options on that. We have to look at that hearing in light of this order today, and we haven't made any decisions yet, but we're going to do everything we can to reunite Kelsey with her baby when we can get the judge here to look at the case anew and figure out that issue. So it's in the works.
And it sounds like you were trying to fight her on that 58A dangerousness finding. Why was that an important step? It's just a step that we felt the judge didn't need to go that far. There are other provisions in the bail statute where someone can agree to terms of release. The court is empowered to make certain terms of release on its own. So we just felt that it wasn't necessary to go to that level of making such a declaration. And we'll have to see where that goes in the future. But we're optimistic that all those issues will be ironed out in the short term. And for now, obviously, we're going to do everything we can to comply with all these provisions. Thank
Yeah, so keep that in mind. All of those provisions. Okay, so remember, the court decides you're released. Here are the conditions you must follow to stay released. So,
and before we do those conditions, let me just acknowledge a couple people, if we could, Michael, almost like an intermezzo. Joey Kane, gift of $1 TV membership, and you have to be a subscriber to get that membership if you're a gifter. So if you are not subscribed, you should subscribe, and then they're randomly assigned. We have nothing to do with it. Joey Kane gifted another one. He's been very generous to our network, and Sherry Schreiber also gifted another one. And Sherry, we are working on that. We already have 2 guests ready on that other matter that we've talked to you about, and look forward to it. All right. And then Josh H has a question that I think we can answer, but we have so much more to go through with regard to this. Can he show proof that there was communication on that date? Let's dump his phone or get his phone records to show they spoke. Yeah, I think we're gonna see a lot of Cellbrite records in this case, because this case is now taking on a life of its own, Josh. But that's a really great question. Charlie Lynn, new member, welcome, Charlie Lynn. Madeira Beach caregiver.
Hey, Madeira Beach caregiver.
Love MB, love the new spectacles. Yeah, Madeira Beach is our hospice nurse, and as I said, we are Michael and I have taped a short that we'll be putting up soon, just on postpartum depression, and we'll be doing a longer episode on that. But before we get back to that story, because I know this, some people say, well, this is old. Yes, because we're trying to now here tonight tell you the story up until the recent filings of yesterday,
yes.
Because we're going to be covering it. So this is your primer or your primer. So Michael, take it away. And okay. I would point out one other thing. We're doing this, and again, my interest in this is this whole idea of postpartum depression. If you recall, I know everyone's going to say, and I've seen the chats already, Andrea Yates. This is not the Andrea Yates case, because she was getting treatment for their postpartum depression, where Andrea Yates was not at the time, and that's and it wasn't really, people were disputing whether postpartum depression was a psychiatric condition, which it is, and it is transient. It does usually go away after 9 months. In some cases, it can develop into postpartum psychosis, but that's when it's usually untreated. Okay. And almost every celebrity, 1 out of 10 women have had it in giving childbirth. And Brooke Shields is one of the most famous people that first went out with the fact that she had it. And we've seen so many others, which we'll be talking about as we talk about this case with the overlay of postpartum depression. Okay, Michael.
So what happens then is, okay, you see she's released. She and her attorney make their comments and move along. And then at some point, you have to remember that those conditions that are set by the judge are monitored. And if you don't follow those conditions, then you can potentially be violated and your release is revoked and you're going in the slammer. Along the way, not because there was a violation, not because she was turned in for doing something wrong under the release agreement, but on their own, Mr. Bradel took his client, Ms. Fitzsimmons, back to the court to get a modification. Why? Because there's a test that was required as part of the release agreement. It's called a SCRAM. I don't even know what the acronym stands for, but it's a blood alcohol test. It's a breathalyzer. Some of them now, they do it electronically. You never have to do a thing. It just monitors however it does it through skin or whatever. But the one that she was required to do was the good old breathalyzer. I thought I had one here from, because my teenager was, he just graduated college, but back in the day, we used that little thing. I couldn't find it, but it takes a sustained wind. And maybe if you've been shot in the chest, maybe if you've had 2 surgeries, maybe if you spent 52, 53 days in the hospital recovering from that wound, maybe taking a deep breath is painful, or maybe you can't even do it.
You can't even do it on a regular situation. When I had my hips replaced, right? And it wasn't a breathalyzer, but they had to give you a thing that you breathe
that's
through, right?
to check your tidal volume. Yeah.
To check your device. It's so hard because every time you take a breath, something else in your body hurts. And that wasn't being shot in the chest and being, having 50 some days of treatment. So it's very difficult. And
it's just a practice. And remember,
4 times a day, she has to do it.
That condition had nothing to do with the crime for which she was charged because it wasn't an alcohol-related offense. But the judge imposed that condition. Not all that unusual, but that's in place.
And even though people say she had alcohol problems in the past, she was cleared to go back to work right soon. She had gotten her firearms clearance back from the postpartum depression. She did not have postpartum psychosis, peoples.
And so I want to make clear that alcohol was not related to this incident, but the testing was. And so she was trying to do it on their own. They went in. You would never go in normally to address, hey, my release conditions. What about this? You would normally only do that if you're violated by somebody in the system. So they go in. They want an alternative testing process. And just like I mentioned, there are other possibilities. There are electronic monitoring. There's urine tests. They even suggested random urine tests. And
the NFL players have, like all the sports players have.
And the court said, no. In fact, not only no, but you violated your conditions of release by not providing these tests, these 4-day tests. And so what was going to be just a hearing to get a new accommodation under the release agreement became much more than that. And so what I want to show now, because we're still a few steps from getting where we're going, but
we're still a few steps because everyone should also know that her probation officer, along with the police department, said she was okay. So when you listen to Michael, okay, listen to it in light of what that the police said she was coming back to work. She was getting treatment for postpartum depression, and her probation officer said she's okay.
Yeah. So that all of those things make this just a bizarre sequence of events, and it gets worse. So they go in. The judge decides to make a ruling based on the evidence available. This is audio from just the very end of that hearing, and it does come from I stole it from Jess Bichotto's site.
Thank you, Jess.
Yep. Thank you so much. Appreciate that. And let's just listen to the last. This is basically, I may back it up a touch here. This is
And
basically.
I may get this. I may never be allowed to practice in Massachusetts again, where we had the not guilty for the double murder by Aaron Hernandez, because I called the judge an asshole at the beginning of this program because of her not taking postpartum depression into account.
I'm not going to report you. Okay, let's listen to this is basically the end after the arguments have been made, and the judge makes a ruling.
The scram device. So, do you have anything else to submit, Attorney Brado?
No.
Okay, Commonwealth, do you have anything?
No, I have no evidence to submit other than the arguments that I talked about, how important that the Commonwealth's belief is in light of the court releasing the defendant, that testing be done.
Okay. Attorney Brado, here, first of all, I do have a question. So, Ms. Fitzsimmons is able to do the scram, is that correct? Or is she not able to do it? I don't know. Is she not able to do it?
I think, that depends on whether the court is willing to tolerate the material represented in the affidavit.
The court is not tolerating anything. Okay, let's be clear. I'm not tolerating anything. The court is not tolerating anything. Ms. Fitzsimmons is a defendant. In lieu of incarceration, my order was that she submit to scram. If she cannot do that, I need to know that. Can she do that or not?
She can do it.
Okay.
Under the terms that are laid out in the affidavit.
So you're saying she can do it on her own terms?
With significant pain and dizziness and having to recover for several hours.
I understand what you're saying. It is certainly not the court's intention. It's not the court's position to have Ms. Fitzsimmons in any pain at all. So I appreciate your argument. Do you have anything else to add?
I would suggest, Judge, that I think there's other ways to do this. If the court wishes to have her tested for lack of alcohol, that's completely fine with the defense, but just the means that's being employed is kind of a torture device for her.
Okay.
And so we object on due process grounds to that.
Oh, okay.
But
it is not this court's intention
I understand
to torture Ms. Fitzsimmons at all. The court's goal is to make sure the community is safe and Officer Noonan is safe. So I hear you loud and clear that the defense views Ms. Fitzsimmons having to do the scram as cruel and unusual and torture. Is that your position?
Well, that's an Eighth Amendment position. I suppose that can be put in there as well. But Judge, I think that, there's probably other alternatives that she could do that I believe are out there. But I know that might step on the court's other order for house arrest, that you would have to go to a facility. I know there's like urine tests and other things like that. So I know there's other possibilities out there that, again, she's not trying to use this to create a situation where she can go drink alcohol.
Okay.
That's not at all what this is about. So I just want to ask the court to consider any other alternatives that might not pose this type of an issue.
Okay.
Thank you.
Attorney Gubitosi or Attorney Moriarty, do you have anything to add?
No.
Okay, I'm going to leave the bench for a few minutes. I'll break.
Court, all rise. Goes back in session.
Your Honor, we're back on the record with the Fitzsimmons matter.
Okay, good afternoon, everybody. So I have reviewed everything again that's been submitted to me. And I will state for the record that Fitzsimmons has moved twice in a 3-day period to amend her conditions of release. On neither occasion has she submitted any medical evidence to support her claims. The imposition of conditions is the court's order after careful consideration of the evidence to fashion the least restrictive conditions that will reasonably assure the appearance of the defendant and the safety of all other persons in the community pursuant to General Laws Chapter 276, Section 58A2B. Just days ago, the court concluded that the condition of remaining alcohol-free and submitting to scram monitoring was necessary to ensure the safety of the community. After a thorough review of all of the arguments and submissions by the Commonwealth and Fitzsimmons, that conclusion remains unchanged, regardless of Fitzsimmons' claimed physical limitations. Based on an affidavit submitted by Fitzsimmons' mother, the testimony of Assistant Chief Probation Officer Jeff January about his observations of Fitzsimmons' apparent pain during the scram installation, and the representations of Fitzsimmons' counsel that it would be cruel and unusual punishment and torture to continue to require Fitzsimmons to comply with the condition of being monitored by scram, the court concludes that Fitzsimmons cannot abide by the condition of being monitored by scram. Without this condition, which ensures that she does not consume any alcohol, the court cannot assure the safety of Officer Noonan and all other persons in the community. Accordingly, the court's prior order of release is vacated, and Fitzsimmons is ordered to be held without bail pursuant to Mass General Laws, Chapter 276, Section 58A. And a written order will follow.
May I address the court?
That's the court's order. Thank you.
All right, Jack, I ask you to stay your order pending the SJC. And there are other alternatives Your Honor can accomplish.
So, and you can hear at the end of the recording how Ms. Fitzsimmons was reacting to what was clearly a blind side. You know, some of the setup language was, we understand your concern. The court certainly not looking to torture her, and but you know, when Mr. Bradel made the Eighth Amendment argument, which is just an argument you're going to make that it's cruel and unusual punishment, she latched onto that. Like, that is so outrageous and so ridiculous that I'm going to hold it against you for even suggesting it. You could just tell it. It was in her voice. And I guess we should see what this stellar judge looks like. I think that's only fair. Let me find the picture I have of her. So that's where that was just the 11th. Okay.
Right.
That was last week.
Right.
And so
so then Bradel goes out. He's actually Kelsey Fitzsimmons is represented by two attorneys, and I want to mention this because there was a question, but also there seems to be someone in our chat. I think this was a negative. Sarah B. Creative is in our chat. Look at who Bradel's representing. Doesn't take 2 + 2. I mean, I don't know what you mean by that. Okay, and here we take all opinions on this chat. I've represented Casey Anthony. I've represented Phil Spector. I represented Aaron Hernandez. As the criminal defense attorneys, we represent people. Okay, who some are charged, some are guilty. I've also represented a lot of people who have been wrongfully convicted, who have been let out of jail when they were this close to the death penalty, when other people committed their crimes. Okay, so I think that who we represent should not be a part of this discussion. I don't know if you said that goodly or badly. We want you to be involved in talking about it, but I don't think this should be personal about the attorneys here. He went and he's representing his client, and quite frankly, he's invoked Martha Coakley, who used to be the Attorney General, former governor, as co-counsel here, trying to give it some gravitas and some juice. But as we're going to see, apparently it hasn't worked, because the judge, who I have called, and I will say it again, an asshole, and I do that in my journalistic capacity, not in my lawyer capacity, because I'm not on this show as a lawyer, but as a journalist, okay, is just, you heard that, wouldn't even let, as Sheila points out, the ankle bracelet being taken off monitor during her surgery, okay, which was supposedly be the next day. I see my friend Dr. Peter Dean from England has signed on as a subscriber. We will be having Dr. Dean on the show in the future, because he will talk about how England handles these type of cases with postpartum depression, postpartum psychosis, a lot different than we do in the United States. Perhaps the judge should go to England. Okay, so anyhow, that's
and there she is. That's her. That's Judge Kathleen McCarthy. So remember that face. I would imagine she's I don't think willing to showcase her work, which is why there was only audio of that hearing. So going forward, who knows? This case has certainly taken on a much larger profile. So
you're blurry, by the way. People pointing out, Michael, that you're blurry. We have
I'm blurry. I try not to be.
Is just like Michael? No, he's blurry. He got blurry. You know why he's blurry? Because he's been crying over this. I'll tell you, Michael's been the one insisting that we get this case on the air quick. So we have a primer for those who are not familiar with it. But that may have to do with his router. He may have to change his.
Yeah,
router.
I think.
And while you're addressing that. That's Michael. That's not the correct judge that you put up there. Somebody's
saying that's not the correct judge.
Yeah, and it's not. I should have said that. Kay Schmidt.
I only looked at 5 different sources, so please
Kay
tell me which one it
Schmidt,
is.
Bryant and Baden Media Company gifted 5 Justice Serve TV memberships, okay, for us. And that means if you are a subscriber, which you should do right now, all right, you can be eligible to get one of those free subscriptions from people that are so generous, okay?
Yeah, I believe that is her. I mean, I've looked at many sources, so anyway, maybe that's just too good a picture of her.
Yeah.
Yeah, I believe Oasis Cat, I believe it is. But anyway, Judge Kathleen McCarthy hyphen Naaman. Anyway, so we had the hearing. We saw what happened. Let's move on from the next step. So we have the hearing. Clearly, she's decided that the release conditions have been violated. Boom, you're going into
even though it's Kelsey Fitzsimmons who came to the court and said, I can't comply with this. It's too
yes, that's why I said that up front.
So I want to tear my hair out here.
That's why I mentioned that up front, because that's just very rare for somebody to voluntarily do that. So Mr. Bradel then comes up with a motion to reconsider that.
This is where she's jointly represented by Bradel and the former Attorney General of the state of Massachusetts, former Governor Martha Coakley.
So if we just look through some of the tidbits here, it references Scram. It references the testing. There's testing facilities as an alternative. You also may have noticed that the judge mentioned that there had been no medical records provided to support this problem. And so they provided a detailed report from the doctors to give the court that basis of information. Didn't matter. It was after the fact, though. So maybe if the judge had been given the material at the same time, maybe. But of course, because for the reason we mentioned, they were doing this voluntarily to get this condition changed. They probably thought, well, why do we need it? We're not coming in here saying, here's why we violated it. We're coming in saying, here's how it would make it easier to comply. So anyway, let me go to the second page of the motion for reconsideration because it has some of the juice on it. Let me find that real quick, like here, and we'll learn a little bit more about what the arguments were for reconsideration, which is, by the way, one of the toughest motions you'll ever bring. You have to bring it in front of the judge who has denied your prior motion. And as I like to say, it's kind of like asking your folks who've told you to go to bed if you can stay up for an extra hour. It's like, no, you're not going to get to do that. So this is the second page. Let me enlarge that a little bit. The court can accomplish the goals with the alternative rather than incarceration without causing Ms. Fitzsimmons undue pain. Counsel has been informed by probation that this testing method is available in this case. And then we're talking about urine testing. Thus, the court may order a less restrictive alternative than incarceration that completely addresses the court's concerns over alcohol use and the safety of the community and any person without the severe alternative of incarceration. Remember, Officer Noonan was mentioned a couple of times. That was the officer that shot her, that they, in the charging of this crime, construed what she did with the gun, which she said was pointed only at her head, was to harm him. And so he's become this protected alleged victim to the court's concern anyway. Defendant presented to the court that attempting and completing the scram caused pain at the time as well as 3 to 4 hours thereafter. Court acknowledged she did not want the defendant to be tortured, but did not consider other alternatives that would accomplish the goal without pain to the defendant. The court's revocation of all conditions to send the defendant back to jail is worse by far than even requiring her to submit to the scram. Aside from her total loss of liberty, the defendant is a police officer and a former corrections officer who would face serious risk of bodily injury in such a facility. So you get in the picture here, Right. Ms. Fitzsimmons is requesting an expeditious determination of this issue and does not request an in-person hearing. Defendant requests an expedited response from the Commonwealth reporting their position to the court consistent with the case law provided in the site given there. For the foregoing reasons, she asks the court to reconsider its order of incarceration on this date and return her to her house arrest. Remember, it was house arrest too, with the same conditions ordered. Now, what was the result of this motion of reconsideration, which was not a hearing? What was the result?
Let's see. Should I take an
Should I get
educated guess?
the magic 8 ball? Should I ask the magic 8 ball?
Yeah, get the magic 8 ball, and you're
Yeah.
getting blurry again, by the way.
Oh, my gosh.
But the decision, you're very blurry right now, and maybe that's so while you're correcting that, before we keep everybody let's look at the judge. Okay, Oasis Cat, this is and Dizzy said this is the correct judge. Okay, maybe all of us who have blonde hair look alike. Okay, so you're correct. There you go. You're unblurried. Okay. Okay. Yes, we are concerned about the baby separation from the mother. We haven't gotten there yet, Lizzie. All right. So, what do you think the decision was? All right. What was the decision? We all know what the decision was. Denied, right? And then I can read in sum, there has been no change in circumstances or newly discovered information that would warrant revisiting the court's decision pursuant to whatever the Massachusetts law is, nor has there been a showing that substantial justice requires it. Ordering for Simmons to remain alcohol-free and monitoring her for alcohol use with Scram device was critical to the court's decision to release her on conditions and in lieu of incarceration. Fitzsimmons has had multiple opportunities to advocate for conditions of release she could comply, which would satisfy the court's concerns regarding the safety of the community. Officer Devers, Sergeant Proctor, let me just digress. As evidenced by the dialogue that has taken place between Fitzsimmons, the court, and probation over the past 2 weeks prior to the September 11th hearing. Her failure to transparently provide information related to her ability and willingness to abide by the conditions imposed despite 3 lengthy hearings is a manipulation of this court's efforts to fashion the least restrictive conditions of release that would both allow her to avoid incarceration and reasonably assure safety of all other communities as required by Section 58A. The court does acknowledge receipt of defendant's supplemental exhibit filing on behalf of the motion pending for reconsideration, motion paper number 28, filed with the court on September 15th, 2025. It does not alter the court's decision, or should I say, made up mind decision that she had already made. Okay, so that's what happened. So she is in jail. She is in jail. Okay.
Yep.
And what is amazing is, as I read all the comments, remember, she was cleared to return to work when she was shot. Okay. When this affidavit was rendered, she was cleared to return to work by the police department. She'd been through all the psychiatric protocols. Her psychiatrist said she was cleared to return to work. Let's put that into the hopper. What you did 10 years ago, what you did at your bachelorette party didn't matter. Okay. She was cleared to return to work. Okay. So, all right. So, Michael, you had an older picture of the judge. We have the newer picture of the judge.
Oh,
again,
I had a more flattering picture. That's what I had.
That's what you had. That's why people said it wasn't her.
Yeah, that's a bad sign.
That
was a bad sign.
So let's talk about the other aspect. Yeah, she's in jail, right? And there's something else that was filed yesterday.
Yes, and that's not all.
And that's not all. And remember, now that we have the postpartum, okay? Now that we have the treatment for postpartum acknowledged, now that we have the fact that she was cleared to return to work, now that we have the fact that they came in to ask for less restrictive conditions because she was shot in the chest and spent almost 2 months in the hospital for being shot in the chest. She'd been separated from that child for 5 months, about 5 months.
And I'm assuming, I don't have this answer for sure, but I'm assuming that the father, Justin Alien, that he has the child. I'm just assuming that.
Right. And then the family would have the child. And you're going to assume that because of what you're going to show next, which is going to be, it's going to outrage you more. But let me just tell you, having done some criminal cases with regard to this, and Michael, you know this, the longer the baby stays away from the mother, let's assume she gets out of jail next year, they will say that it's not in the best interest of the child to return it to her because the child has formed some kind of symbiosis with whoever the caretakers are there. And she may not get that child back, or even visitation. They'll have a reunification, but it could be visitation like 3 hours a week, or 3 hours every 2 weeks, or whatever. But it's not taking care of your child when your child's young. So with the postpartum depression, with the diagnosis, with the treatment, with the fact that the baby is also a victim in this, the story continues.
Yeah,
Michael,
and the baby was only 5 months old, which which makes his bonding argument, the father's bonding argument, so much better, right? You know, this is he is in all likelihood, best case scenario, going to have had that child maybe an equal number of months that she had the child. That would be a good scenario. Anyway, so filed just yesterday was this little goodie, and this was filed by Justin. You can see the spelling there, why we are struggling with how that's properly pronounced. Some would say alien, some will say alien. Anyway, comes now this plaintiff, and what does he want? He wants to attach real estate for the payment of child support. Yeah. So that's now before the court. Here's the procedural background. The child is now 7 months old. So he's had the child for 2 of 7 months. She had the child for 5, not to mention carrying the child. Talks about, where they live, what's going on. Look at this, number 7. This is procedural history. 7, on or about June 30, father sought and obtained an emergency abuse prevention order from the Essex County Probate and Family Court, granting father sole custody of the minor child and ordering mother to have no contact with the father or the minor child. So that's in place now.
So this is an order to attach assets because he wants the sale of her house to go for him for child support after he took the child away. And I guess, he's just supporting the child with his family or whatever. All right. Cheech, actually, yeah, Cheech, you talked to my eye. Yes. Cheech, hi,
hey, Cheech. Hey,
Cheech. The father's basing on the selling of Kelsey's house because he wants the equity of the house for the child. Just what I said.
I mean, this is some master planning here, and so look at, here are the conditions. On or about August 28th, these relate to the release. Mother was released on bail to be set at personal recognizance. The conditions were GPS, 24/7 house arrest, except for medical court attorney visits with 48 hours notice to probation, reside with mother and stepdad, no weapons in the home. That changed when she got her gun privileges back, which was just before this happened in June. No alcohol with Scram. Sign any and all releases, follow treatment plan by MGH, which is the hospital. So those were the parameters that they went in to change. Hey, we want to change number 5 and just have urine tests, whatever the court would allow.
And for everyone that knows, by the way, has been involved in this, which people may not know, when you are a defendant and you have an ankle monitoring bracelet, you pay an exorbitant amount every month to the monitoring company. You're paying for that when it gets attached to you, when it gets taken off, when it gets monitored. So the urine tests may even be cheaper to do because they're so inexpensive these days. But the monitoring companies make a fortune with their contracts with the government.
And in theory, if you have the ability to do the Scram, it's more convenient for everybody. Nobody wants to have to leave and go do a urine test, but that was being offered as an alternative. So if you just look at the legal standard here, it doesn't look all that good. The court may authorize the attachment of real estate when there is a reasonable likelihood that the plaintiff will recover judgment in an amount equal to or greater than the amount of the attachment, and such attachment is necessary to secure satisfaction. Well, to me, we're a few steps before even getting there. They're talking about how to execute on a judgment, right? There's no judgment. There's no outstanding bill. That's down the road. So that tells you to me how long term this planning might have been in play. If we do this, we get the child. Next step is we go after the property to cover child support that we're going to assume she won't pay because she doesn't have a job now, right? And she's still, being treated. So that's where this is. And the rest is more about the legal necessity to do it. There are a couple of nuggets in here. This is, to me, hot off the press. I mean, it is, I don't think it's been reported. I haven't seen it reported anywhere else. I may be wrong. If I am, please correct me, but it was just filed yesterday and I have not seen much on this thing.
Yeah, so he waited until the motion for reconsideration was denied and then filed this, I think, in the timing, right? Is that it? Or do I have that?
That makes sense. Backwards? Well, no, because the denial did come before this. And this is filed in a separate department, right? Mother acquired title to the Phillipsbrook Road property by quitclaim deed on or about June 27, 23, right? Shortly thereafter, she got a mortgage from Cambridge Trust Company in the amount of $388. It's a 1,287 square foot single family residence, 3 bedrooms, 1 bath. On or about August 22, 25, mother and or her family listed the property for sale at $599.99 as reflected in Redfin, which is an interesting wrinkle. Obviously, or at least it seems to me, that she was downsizing, right? That, it's her and the baby, and she needed the money more than she needed a house with 3 bedrooms. So, and that's what they believe is the only asset that she has.
Right, and remember, they were supposed to get married, the father of the child and all.
Well, I think that probably stopped at the time of the restraining order. That probably killed that deal.
They're just so she's going to have a lot more hearings because you're going to have you have all of this going on, and she's in jail. She's in jail. This case breaks my heart, and we're gonna. But it really is a point for us to talk about the whole idea of postpartum depression, right? That again, we've taped something. We'll be releasing it sometime before the weekend on postpartum depression. We'll be looking at Brooke Shields' book, which was phenomenal when it was published in around 2003. You all know who Brooke Shields is, and a lot of other famous people who have spoken about it because it used to be taboo to talk about it. And we'll be talking about how many women have it, and we'll be talking mainly celebs initially, but then we're going to be doing an episode involving this case specifically. And if your father or parents or anybody's watching, please, we invite you to email us at justiceservedtv@gmail.com, because we have been reaching out to a number of mental health professionals who even deal with the issue of this and postpartum psychosis, which she did not have. Okay. She did not have.
Let me just wrap up the numbers here on this so you can see what he's going after. There's allegedly, if you look at the sale price, do I have to get out my real estate broker's license again? If you look at the sale price versus what is owed, he's assuming there's a $211,999 equity, and that's what he's going after. There is a footnote that says the price was recently reduced to $579, which suggests maybe it's not a seller's market in that particular area. So the true number in terms of equity is already down to $201. And it could drop further depending on the ultimate sale price of the home. But this, to me, just again suggests long-term plan. This was in the works for some period of time. Whether Mr. Aleo, whether it was just him or he had a team working on this, family members, who knows? But this was not last minute, in my opinion.
Thank you, Marge, for becoming a new member, and thank you, Karma D. Harma, who's one of our members who always posts, who has an opinion about Wendy Adelson, I guess, and off. So, but I tell you what it does when you start getting into it, because we have not covered it. But as I said, Michael Bryant's been hot to trot on getting us into this case, getting you all caught up. And since it doesn't look like she's going anywhere, including to surgery, which apparently she needs as a result of being shot, all right, and all the other medical problems that have been unleashed in her court, and we don't even know if she's getting treatment for the postpartum depression in jail, right? Although she may have been past that by now, because she was clear to go back to work, so she probably was past that just at that point, just past it.
There's a good question I just saw fly by. Let me.
Okay, there's a lot of great questions tonight.
KPT, couldn't Noonan come forward to say he's not afraid of her? Would that have had any bearing? DV cases sometimes say no assaultive contact. I think that's such a misinterpretation, not the question. What the judge did is such a misinterpretation of the facts, of the underlying facts of the case, right? But if the judge says anything that diminishes the current charges, then it would look like she's watering down the prosecution's case from the bench, which she can't do. By saying, well, Mr. Noonan has nothing to worry about. Well, then why is she charged with assault or attempted assault, right?
And why is the judge so worried about the community's safety? I mean, my gosh. I mean, can you imagine?
It's just so ignorant. It's just, I don't know if she's just downright stupid, or maybe she is an asshole, like you suggest. But I do know this.
You know what? I'm going to take that back. I'm going to take that back.
You take it back?
You know why? Because even assholes have a purpose.
Hey, yeah, you're right. Generally. All
right. You know that I don't hold back on the show when I can be a journalist and not a lawyer.
I'm going to do this. I am going to find a more current, less flattering picture because apparently that's annoying people. That's a few years old, I guess, but it is her. Just she's had some rougher days since that picture was taken, I suppose.
Yeah.
Okay. All right. So that's what we got. That's where we are. We're going to stay on this, of course. It seems to have some day-to-day developments. I'm going to continue to reach out to Mr. Bradel. I will see him next week when we're up there covering Aiden Carney hearing. So stay tuned. This is a very interesting case, and it's just so exasperating when you see this happen in front of you, and you just wonder, what world am I in? This bizarro world where this judge has no clue what is really happening here, has no way to weigh true threats against the public or Mr. Officer Noonan, and what's happening to this woman and what has happened to this woman. It just seems so ignorant.
Yep.
Okay.
All right, everybody, it's been
Okay.
a tough week, as you know, in the world. Oh, by the way, thank you so much, Shannon in Arizona, number 5. And thank you very
Thank you,
much.
Shannon in Arizona.
I'm just so incensed by this case that Michael Bryant got me involved in to take a look at today, and he knows that I've been bugging him. Oh, I'm going to take this. I'm going to take this. I really want you to know. And we will cover. I think we're going to also do, for those of you who don't know, the Andrea Yates case. That was postpartum psychosis, but it's an old case. But you know, that's what people are misconstruing. Postpartum depression with psychosis. But I think we'll take a quick look at it. Maybe we'll do a short, Michael, about the Andrea Yates case to show, you know, because people have said, well, that's what Justin was trying to prevent. He was trying to prevent that from happening. So,
yeah. Well, you know, and again, on its face, that may have been fine, but when you know the whole story, it doesn't make any sense. So,
yeah.
All right, then. Yeah, again, stay tuned. We will continue to follow this case, bring it to you as it unfolds. In the meantime, I'm Michael Bryant. You're Linda Kenney Baden.
I'm Linda Kenney Baden.
This is Just to Serve TV. Please try to do the right thing.
On the